Hi everyone, my name is Noah and I'm Maria's virtual assistant. Today, I'll be walking you through the disability intake process for prospective clients applying for Social Security disability benefits. This training is designed for legal support staff, especially those new to disability law or looking to strengthen their intake approach. So, who is an ideal client for a Social Security disability case? While we treat every prospective client with care and respect, experience and the law have shown that certain factors tend to result in stronger cases. These include: the person is age 50 or older, they have a steady work history, especially in physically demanding jobs, they've stopped working due to serious health issues, and they are actively seeing doctors and engaging in treatment. Let's talk about age 50 specifically. The Social Security Administration uses a set of rules called the Medical-vocational Guidelines, or the GRID, to determine disability. These rules consider a person's age, education, and work background. They tend to be more favorable once someone turns 50, especially if they can no longer perform physical work. For example, a 55-year-old who worked in housekeeping or construction and now experiences chronic back pain or arthritis may have a stronger claim under these legal standards than someone younger with the same condition. These aren't preferences, they're written into federal regulations. Understanding how these rules work helps us assess claims accurately and serve clients effectively. Now that we've covered what makes someone an ideal candidate for disability benefits, let's talk about how we evaluate their medical and work history during intake. As an intake specialist, your job is not to decide whether someone qualifies. It's to gather the right information so the attorney can make that call. That means asking good questions, listening closely, and flagging anything that might affect the case. Let's start with medical history. We want to understand what medical conditions the person has been diagnosed with, what symptoms they experience, how often and how severe, what types of doctors they're seeing, such as primary care, psychiatry, orthopedics, or rheumatology, and what medications they're taking and why. Clients don't always use clinical language, and that's okay. If someone says, "My knees are shot," or "I can't stand for more than 5 minutes," that's important. Document what they say clearly and respectfully. If you're unsure how to phrase something, do your best and move on. You can always follow up later. Next, let's look at work history. We're especially interested in what the person has done over the past 10 years. Ask, what kinds of jobs have you done? How long did you do them? What were your responsibilities day to day? For example, if someone worked in retail for 8 years, ask, did you stand all day? Lift boxes? Supervise staff? The physical and mental demands of past jobs help us understand what the client can and can't do now. Finally, ask when they stopped working and why. This helps connect the dots between their health and their ability to work. For example, I had to quit my job at the warehouse in 2021 because my back pain got so bad I couldn't finish a shift. That's important. Document it clearly. It may become part of the core theory of their case. Great job making it this far. Now let's talk about what happens after the intake interview, specifically how to flag key details and help the attorneys start building the case theory. So what do we mean by case theory? In disability law, a case theory is a short explanation of why we believe this person is disabled under Social Security rules. It connects their age, work background, and medical limitations to the legal framework. Common case theories include: the person meets a listed medical impairment, their condition causes them to miss too much work or go off task, they're limited to sedentary work, and their age or background makes retraining unlikely, or they qualify under the Medical-vocational Guidelines, also known as the GRID. You're not expected to pick the legal theory, but your job is to gather the clues that help the attorney build it. So how do we document intake effectively? After the interview, your notes should be clear, factual, and free of judgment, written in plain but professional language, organized so the attorney doesn't have to dig for context. You might include a short summary like this: client is 55 with a 12-year history of warehouse work, reports back pain and arthritis in knees, hasn't worked since 2021, treating with orthopedic specialist and receiving injections, likely meets age and work history criteria under GRID rules. That kind of note is gold. It helps us prioritize the case, understand the timeline, and make quick, informed decisions. Quick tip before we close: if you ever feel unsure, flag it. Ask questions. Intake is one of the most important stages of a disability case. and your work sets the foundation for everything that follows. Thanks so much for being here today. My name is Noah, and on behalf of Maria and the DAG team, we appreciate the care and attention you bring to this work.